Shalom, my name is Michael Decker, and I'm a lawyer within the law offices of Cohen Decker, Pex and Brosh. Today I wanted to discuss a situation which arises frequently in Israel, which is unfortunate, and it arises with regards to couples in Israel when one member of the partnership is a foreign spouse and the other member is an Israeli, and they have opened a joint life application, and the joint life application has stopped and ceased due to the unfortunate passing away of the Israeli partner, which leaves the living foreign partner as a widow. Due to humanitarian issues that arise as the foreign widow left his country to live in Israel and perhaps purchased a house with the Israeli spouse, connected to the family of the Israeli spouse. Perhaps this couple have joint kids together. And due to all these, the Interior Ministry enacted a policy whereby a special humanitarian committee will deal with various cases on an ad hoc basis. In the year 2009, the Supreme Court rendered a decision after many petitioners, plaintiffs submitted petitions, and the Supreme Court unified many of these petitions to deal with various questions that arise regarding the 2006 policy that existed. This case is called Daniela Hillel versus the Interior Ministry. The Supreme Court number is 4711 on 02. And basically, the decision that was made was to better and to improve the policy from 2006. So as of today, and due to this court ruling, if there's a foreign widow that was not yet naturalized in Israel, and if the couple had children, then the case of the foreign widow will automatically be reverted to the humanitarian committee, and the status of the foreign widow will be renewed until a final decision is made. If, however, this couple did not have children, then the agreement in this ruling was that if half of the time period for the naturalization process, which usually takes 4.5 years, so half would be 2.25 years, if half of the time has passed, and if the relationship was an authentic relationship and there was no dispute in this regard by the Interior Ministry, then this widow's case will be transferred to a humanitarian committee. Our firm lately dealt with a similar case of a widow of an Israeli that lived in Israel for 18 years, was here as a foreign worker, and then met an Israeli. They got married, and unfortunately the Israeli passed away before the gradual process ended, almost towards the end, and the Israeli spouse left the foreign widow an inheritance, and the foreign widow connected very closely to the family of the Israeli and left her country and lived in Israel for a very, very long time. The Interior Ministry the Humanitarian Committee rejected her application to stay in Israel, and our office submitted a petition to the Special Immigration Tribunal, and the Special Immigration Tribunal did not agree with the decision that was made and decided that the Humanitarian Committee failed to properly examine all the links that were built between the foreign widow and Israel, and particularly the family of the widow, of the spouse who passed away, that the living widow basically connected with, and all the other links that this living widow had in Israel. And the tribunal sent the case back to the committee to make a new and proper and correct decision, and ruled in favor of the petition, and even granted her and forced the state to cover her court costs. If you have a case like this or a problem similar to this, you can feel free to contact us, and we'll be happy to be of assistance. Thank you very much for your time.